Please refrain from asking questions as we proceed. Let us reserve our questions for the end of the session, where I will allow specific time for the asking of questions. We will finish slightly early to allow for such questions to be asked. Also, because we have some of our colleagues joining late, it can be a bit disruptive, and that is why I would prefer that questions be asked at the end of the session. And lastly, I would like to please request that we ask relevant questions to the subject at hand. Last night, we had some questions on topics which are still to be covered in the session, because people did not realize, or they read ahead and they did not wait for me to finish the session. So please, ladies and gentlemen, let us try to stick to those rules and we will make better progress. To kick off then, and I noticed some of you asked me last night on a number of occasions on which page I am. I am not reading the notes. I am not going according to the notes as they are in the notes, in the booklet. I am dealing with the topics on a practical level and not on a theoretical level. I'm trying to give you the experience as it would take place in practice and not in as much theory as is in the books. If I refer to something in the book, it will be because the essence is contained in the book. So please don't ask me which page I am on. I hope that you have read ahead as we had suggested last night, and I gave you the topics which we will be covering today. But before we get to today's topics, I still have to finish off some of yesterday's topics, and I would like to do so without as much interruption. I'm going to touch on certain important aspects which I feel are necessary for me to do so. And as I said, I'm not going to teach you. I'm merely trying to give you the practical experience of the theory as it stands. Right. Now, under the service of process last night, we spoke about the various organs of state. And one thing I'd like to touch on this evening is execution against a government department or an organ of state. Now, execution and attachment refer to the execution of a judgment which a party has obtained against an organ of state or a government department. As a plaintiff or an applicant, a party would want to execute against an organ of state by issuing either a warrant of execution or a warrant of delivery or any other warrant that requests or demands that the defendant or respondent organ of state does something or refrains from doing something. Or in this case, it is for the satisfaction of a debt in terms of Act 40 of 2002. The sheriff has to, in terms of the State Liability Amendment Act of 2011, perform his duties in satisfaction of that execution or attachment in a specific way. And that way is by approaching the accounting officer of the relevant department concerned Nobody else. You must approach the accounting officer, who is normally the head of department. In government terms, it's called the HOD, or sometimes the DDG, or the SG, who is the Superintendent General of the department. And the head of department or the accounting officer of that organ of state must point out to the sheriff which property of that organ of state the sheriff may attach. And normally after an attachment, a party, an organ of state has 30 days within which to satisfy that debt. If that organ of state does not satisfy that debt, in other words, does not pay the debt, the creditor may send the sheriff back to the accounting officer, who is to point out to the sheriff which property belonging to the organ of state the sheriff may remove in execution of that judgment. You need to look in that regard at the case of Matthys versus Ngwate Plaaslike Municipaliteit, which is a 2003 volume 4 Supreme Court of Appeal judgment, and the relevant sections can be found at page 367C to 368B of that judgment. And that citation you will find on page 35 of your notes. All right. Now we are going to move on to, we started with jurisdiction last night, and I want to touch on a few important aspects relating to jurisdiction, starting on page 45 of your notes. And section 28 of the jurisdiction, section 28 relating to jurisdiction in respect of persons, provides the following. Persons in respect of whom the court shall have jurisdiction shall be the following persons. And there you have a list from 1A. As you will see, it is quite extensive up to 1G, listing the different persons over which a court will have jurisdiction. Now you must remember, when we say court, we're referring to the magistrates court, either the district court or the regional court. Firstly, you have any person who resides within the area of that court. Their address, they live in that area. Or they may be carrying on business. In other words, they may be running a business, operating a business in the area of the court. Or they may be employed within the district of that court, which necessarily does not mean they reside within that area. They may be, for instance, living in Pretoria, but they work in Johannesburg. So the fact that they work in Johannesburg can be used to establish jurisdiction of that court. Secondly, any partnership which has business premises which are situated, or any member whereof resides within the district of the court. So if a partnership has business premises within the area of the court, or one of its members, one of those partners lives within the area of the court can establish jurisdiction. Thirdly, any person in respect of any proceedings incidental to this court, any action or proceeding instituted in the court by such a person himself or herself. So if there already has been a case instituted in that case, then that can be used because already jurisdiction has been proved, has been established in terms of that person in that court. Then you may institute another action or other legal proceedings against the same person. If the cause of action, now in every case, civil case that you institute in the magistrates court, you have to establish a cause of action. And an example would be if a motor vehicle accident happened within the area of the court, you would say in your particulars of claim or your summons that the cause of action arose wholly within the area of jurisdiction of the Honorable Court. So there you've established the jurisdiction of the court. Then any party to interpleader proceedings, we will be dealing in more detail with interpleader proceedings when I explain to you. The execution creditor in interpleader proceedings, if that person resides or carries on business or is employed within the district as well, the court will have established jurisdiction. And if the subject matter which has been attached by the process of the court, already it has been established, because there are interpleader proceedings will only arise when legal proceedings have already been instituted out of the same court. So already jurisdiction has been established, but you can use that fact to cement jurisdiction in whatever proceedings, interpleader proceedings arise afterwards. And also, a court may also have jurisdiction where all the parties consent to the jurisdiction of the court. And we will look at section 45 later on when we deal in more detail with where parties consent. Any defendant who appears and takes no objection to the jurisdiction of the court. In other words, if a person is being sued as a defendant in an action, and that person goes to court and does not raise any objection to the court's jurisdiction, that person will have been deemed to have consented to the court's jurisdiction by their failure to raise an objection. And any person, lastly, who owns immovable property within the district or region, in respect of such property or in respect of mortgage bonds thereon only, may jurisdiction be established. So if a person becomes a party either as a plaintiff or a defendant in respect of property which is situated within the area of the court, that person may establish jurisdiction, but only for purposes of any cause of action relating to the property itself or a mortgage bond in respect of that property. I hope I'm making sense so far. Right. Now, the sections in your notes, which I am not dealing with, you will have to read on your own. And towards the end of the week, when we have time, you are required to make notes as we go along of questions that you would like to ask. And then you may ask those questions at a later stage, and I will be glad to answer those questions. It's important then to also look at the jurisdiction of where the state should be sued. Now we know the state is municipality. Well, let's look at the government departments. Government departments are considered to be the state. And you're looking at provincial departments and national departments. The national department, the national government is considered to have its address or registered address where it can be sued as Pretoria. Pretoria has been the address in terms of the previous government. When the 1961 constitution applied, Pretoria was the head office, so to speak, or the residence or place of business of the state. Today, you find that Pretoria is still that national government head office where parties may sue the organ of state, national government. Provincial is different because every province has its own, inverted commas, head office or residence or place of business where you can sue that department. And the minister of the national department must be cited as a as a defendant or a respondent in terms of the requirements, the legislative requirements. So you cite the minister in a national department, and in a provincial department, you will cite the MEC, the member of the Executive Council, as a nominal defendant or a nominal respondent in proceedings against those respective departments. In municipalities, you will cite the municipal manager, who is the accounting officer of the municipality concerned. But make sure that you know the difference. When you cite a municipality, and when you intend to sue a municipality and you want to cite them, you need to make sure that you know the legislation which establishes that municipality. What type of municipality it is also important, and the address of that municipality is also important for you to know. The court may also grant against persons and things orders for attachments, interdicts, and mandament van spolie. We'll explain these concepts to you later on. And confirmation by the court of any of those, of an attachment or an interdict in the judgment, in the action, shall operate as an extension of the attachment or interdict until execution or further order of the court. There you need to look at section 30 in respect of interdicts and what is said there. You may seek clarity on any of these issues at a later stage, but you are encouraged to read the notes on your own. Application for the attachment of a person's property must be made in terms of Rule 55 of the Rules of the Magistrates Court. And that application, which will be a notice of motion, must be accompanied by an affidavit stating the facts upon which the application is made and the nature of the order applied for. And where there is an application for attachment of things, the court will make an order only if it is satisfied that the respondent, and you will look at your notes on page 50, and there you will see that there is a reference to the defendant. That should be a respondent, because you are dealing with an application here. You have the different parties, and we will deal with this also later on. In terms of an action, the parties are a plaintiff and a defendant, and in respect of an application, the parties are an applicant and a respondent. So there when it says the defendant is about to leave the jurisdiction, you should change that to the respondent. Secondly, the court will make an order once it is satisfied that the respondent is endeavoring to dispose of the property in order to evade his creditors. In other words, he does not want to pay, or she does not want to pay. The court will also make an order once it is satisfied that confirmation by the court of an interim attachment of an action operates. That is in terms of section 30, subrule section 2. Interdicts. You might have come across the word interdicts when a party wants to interdict another party. An interdict is a judicial process whereby a party is normally ordered to desist from doing a particular act, in other words, a negative act, or ordered to perform a particular act, which is a positive act. In other words, I want you to stop doing something, or I want you to do something, to compel you to do something. So it's a prohibitory act, and the other one is a compelling act. I want you to stop doing something, or I want you to do something. Those are the two different types of interdicts that you may apply for. It's an extraordinary remedy which has an impact and has the possibility of invading the rights of another person. So the courts are very careful before they grant interdicts against other persons or other parties, that those parties have satisfied the court with regards to the requirements for those interdicts. And you have two types of interdicts. You have an interim interdict and you have a final interdict. A final interdict, you have to, in order to obtain a final interdict, you must allege and prove that the following three requirements are present. One, a clear right on the part of the applicant. In other words, the party bringing the application for an interdict must show that they have a clear right to bring the application. Secondly, the party must show that there is an action, an injury which actually has already been committed or is reasonably apprehended of being committed. So in other words, something that is taking place or something that is about to take place, imminent. And lastly, thirdly, the party who seeks to get an interdict must show that there is an absence. In other words, there is no satisfactory remedy available to the applicant other than coming to court. So the court is the only remedy available for the applicant in such circumstances. Now, next up is something you may have heard of before. We will be dealing with the requirements for an interim interdict when we deal with it in more detail. I just touched on a final interdict with you now in terms of those three requirements. But let me rather touch on interim interdicts. When you want an interim interdict, as opposed to a final interdict, you need to prove four requirements. The first requirement is that the applicant has a clear right. I beg your pardon, a prima facie right. Not a clear right. You only need to prove that you have a prima facie right. Secondly, you must prove that there is an apprehension of irreparable harm that may befall you if you are not given the interim interdict. The third requirement is that the balance of convenience favors you, the applicant, for getting, in order to get, the balance is strongly in your favor as the applicant that the interdict be granted in your favor. And lastly, number 4, you need to prove that there is no other remedy but to come to court for the interim interdict. Now coming to, and you need to look at the case of Chevron South Africa, which is on page 51. Chevron South Africa Pty Limited versus Aways at 110 Drakensberg CC. That's a Transvaal decision of 2008. That is where you need to read that judgment with regards to interdicts. That is one of the leading cases on interdicts. Mandament van spolie, also known as spoliation. Now, spoliation is also a drastic remedy which a party may approach the court for, and where a party has been dispossessed. And I will only say dispossessed because I will show you in a moment what may a party be dispossessed of. And in order to obtain a spoliation order, you must make 2 allegations to the court. You must make those allegations and prove them. And this is done by way of application, so you will be able to set out in your founding affidavit quite extensively what facts you rely upon to prove the following. 1, that you as the applicant were in peaceful and undisturbed possession of the property that was taken from you. Secondly, that the respondent who has taken the property away from you has wrongfully deprived you of that possession without your consent or any due process. Now, this application may be done ex parte. In other words, you don't have to give the respondent notice to say, I'm going to court if you do not give me this thing. You go to court on ex parte, you cite that person as respondent, you ask the court for an order that that person be ordered to return the thing to you, and then the sheriff will go and serve it on that person. They must then give it back to you, pending finalization of the case, or until you have decided to oppose the application or prove that the applicant is not entitled to the order for spoliation. And the respondent, when he or she opposes that application for spoliation, may either deny that they have spoliated the thing, that they have taken the thing from the person unlawfully. Secondly, they may allege that you, the applicant, deprived them of the thing. Or they may argue that it's not possible to return the thing, either because it is not with you anymore, or it has been destroyed or stolen. But those are the defenses which you may raise as the respondent in a spoliation application. But the underlying principle in spoliation applications is to prevent parties from taking the law into their own hands. If someone borrowed, and in spoliation applications, there is even a saying that a thief has a better right over a thing. The possessor of a thing has a stronger right than the owner of the thing. In other words, you cannot merely go and take what you believe is yours from someone. Without that person's permission. You need a court order if there's resistance from a party to return your own thing to you. Because that thief can even go to court and say, I've been deprived of this thing. You don't, and one of the things that you do not have to prove in a spoliation application, you do not have to prove that you are the owner of the thing. So mere fact that you were in possession of the thing gives you the right not to be dispossessed of the thing unlawfully. Emphasis on unlawfully, because there is a lawful way of dispossessing you, which is a court order. Now, when you bring such an application, as I said earlier on, your founding affidavit, which is attached to your notice of motion, must state fully the facts in support of your application, which you are relying on for the order that you want. Right, now, section 30, BIS attachment to found or confirmed jurisdiction, peregrinus. A peregrinus or peregrini, plural, is a person, a foreign person in a country for purposes of litigation. If a peregrinus, if you want to establish jurisdiction of a court over a peregrinus, you need to attach property belonging to that peregrinus or that person. If that person is within the jurisdiction of the court, but the value the claim or the value of the claim in dispute must amount to at least 2,500 Rand. And that must not include the costs of the litigation. So anything less than 2,500 Rand, you may not sue that person for, if that person is a peregrinus, sorry. Now, Section 45, jurisdiction by consent of the parties. Section 45 of the Magistrates Court Act provides that if, and I will make a practical example, two persons entered into an agreement. It was an agreement for a loan. The plaintiff loaned to the defendant an amount of 700,000 Rand. And in terms of the agreement, the parties agreed that despite the amount being over the maximum of the jurisdictional limit of the regional court, the parties consent to the regional court having jurisdiction over the matter. Now, clearly, we know that the jurisdictional limit for the regional court is 400,000 rands. Now, here come these two persons who say that for purposes of this particular agreement, the court shall have jurisdiction in respect of amounts over 700,000 rands. Section 45 of the Act says those parties can do that, but there is a provision which has to be met. And that provision is that the party, other than the jurisdictional limit, the other requirements for jurisdiction must have been met. In other words, the cause of action arose within the jurisdiction. The defendant resides within the jurisdiction of the court. The only jurisdictional issue requirement which has not been met is the amount. And in that case, the parties may consent to the jurisdiction of that regional court of the Magistrates Court. Section 35 of the Magistrates Court provides that the court, any of the parties may transfer a matter from one court to another. And it's normally done by the parties consenting to that court for purposes of convenience. And where such parties agree, they may ask the court to grant an order that the matter be transferred to another court. And the reasons may be, number one, both the parties reside in that court, in that jurisdiction. Another reason may be that in the court in which the matter is heard, none of the magistrates may hear the matter either because they are conflicted in that they know the parties, or because they are parties, or one of them is a party to those proceedings. The parties may then ask the court to issue an order that the matter be heard by another magisterial district or region. Now, Section 46 of the Act states that these particular matters, the court shall not have jurisdiction in these matters, and they are as follows. An interpretation of a will. An interpretation of a will is only heard in the High Court. The Magistrates Court does not have any jurisdiction whatsoever in terms of Section 46. Secondly, any matter in which the status of a person in respect of mental capacity is sought to be affected. So if the status of a person in respect of mental capacity is sought to be affected, that matter may not be heard in the magistrate's court. And an example of that is where a person was involved in a motor vehicle accident, an adult person, and because of the injuries sustained by the person is not able to manage their own affairs. They have now suffered a serious head injury, which impacts on their mental capacity. They cannot appreciate legal proceedings. A curator ad litem as well as a curator bonus must be appointed to represent that person in those proceedings against the Road Accident Fund or any other party. That curator ad litem or curator bonus application cannot be heard, may not be heard in the magistrate's court, but must go to the High Court because it has to deal with the status of a person in respect of their mental capacity. Thirdly, the magistrate's court does not have jurisdiction in respect of cases in which specific performance without an alternative of payment of damages is sought. Specific performance, we know, is something that is required mostly in law of contract, where a party has breached a contract or has not acted in accordance with the contract. That party will be required to act specifically, to specifically perform in terms of the contract. But only when that specific performance payment of damages as an alternative. That case cannot be heard in the magistrate's court. There was a short break there. That case cannot be heard in the magistrate's court. And lastly, if you are seeking a decree of perpetual silence, you cannot bring that cause of action in the magistrate's court because in terms of section 46, the magistrate's court does not have jurisdiction. Now, I see a number of you have joined us since we started. One of the things that I said at the beginning was that, as a rule, we will ask and answer questions at the end of our session. We will finish slightly early, and I will try to answer all questions at the end of our session. You may write down your questions or you may put them on the chat in the meantime. I'm not going to look at the chat now because, as I said at the beginning, we have a lot to catch up on. We are slightly behind, yes, because yesterday we asked many questions, and I'm not saying you must not ask questions. Ask relevant questions, please, so that we can make better progress. And I will attend to all questions at the end of our session. So you either write it down on the group chat, on the meeting chat, or you make a note of it and ask me the question at the end of our session. We'll finish slightly early, say at 8 o'clock, and then we'll allow 30 minutes for questions. Thank you. You will see on page 55 of the notes, you have a diagram which sets out the exceptions to the 400,000 Rand general rule of the Magistrates Court. More particularly, it'll be your regional court, because that's where the 400,000 Rand applies. On page 56, you will see the provisions of section 46 put out in diagram form, which deal with what I've just explained to you are the exclusions. It may happen that a party institutes action out of a court for an amount which exceeds the jurisdictional limit of that court. If the party has proven its claim, the party will not be entitled to the full amount of the claim if that amount exceeds the jurisdictional limit of the court. The court will either grant judgment in favor of the party with the exclusion of the amount that exceeds the jurisdictional limit of that court. So for instance, if a party institutes proceedings for a claim of 450,000 Rand out of the regional court, the court may grant judgment for 400,000 Rands of that claim. Ordinarily, after a party has instituted proceedings for an amount over the jurisdictional limit, the party may, on its own, amend its summons and particulars of claim by abandoning the amount by which the amount exceeds the jurisdictional limit of the court. So that party will bring in a notice of intention to amend and say that the party intends to delete the amount of 450,000 Rand and replace it with the amount of 400,000 Rand, thus bringing it within the jurisdictional limit of the court. The court is then able to award damages or judgment, grant judgment in favor of that plaintiff for the full amount of 400,000 Rand if that party has proven its claim. Splitting of claims. If a substantive claim exceeds the jurisdiction of the court, it may not be split with the objective of bringing it within the jurisdictional limit of the court. It cannot be done. You have to institute action for that claim if you want the full amount out of the correct court. And if the magistrate's court, be it the district or the regional court, is not the correct court, you will not be permitted to split your claim in order to bring it within the jurisdictional limit. The High Court and the Magistrates Court have concurrent jurisdiction. And where the High Court finds that a claim should have been instituted in the lower court, which is the Magistrates Court, the court will advise that litigant, which is normally the plaintiff, known as Dominus Litis, that it is in the incorrect court and that it should go to the correct court, but will visit that plaintiff with its displeasure by ordering an appropriate order in respect of costs against that litigant. Because you must remember, the court rolls, be it the magistrate or the High Court, the rolls are clogged, and it is not in the interest of justice or in the interest of the judges in the court to be saddled with cases which should not have come to that court at all. It is also labeled as an abuse of the processes of court. If a defendant wants to object to the jurisdiction of a court, that defendant must, by way of a special plea, when answering to the summons, say in their special plea that the objection will be in terms of a special plea, and that because of that special plea, the defendant objects to the jurisdiction, that the court does not have jurisdiction, and state the grounds why the court does not have jurisdiction. If the plaintiff is of a different view to what is stated in the replication, in the plea of the special plea of the defendant, it is up to the plaintiff to convince the court by way of a replication, by filing a replication to say, no, the court does have jurisdiction for these reasons, 1, 2, 3, if not more. Now, there are also exceptions to the normal rules of jurisdiction. And one such exception is found in Rule 65A proceedings. So Section 65A in the Magistrates Court deals with debt collection procedures. And only the court which has jurisdiction over the debtor is the court within the area in which the defendant resides, is employed, or carries on business. So if a debtor who's now going to be the defendant, remember, if a debtor lives in the area of the court, is employed in the area of court, or carries on business within the jurisdiction of the court, any of those three, then jurisdiction may be established in respect of that party. Another exception to the normal rules of jurisdiction is the National Credit Act. And Section 29 of the Credit Act gives district courts unlimited jurisdiction because the minister has not determined a limit for National Credit Act matters which are litigated in the courts, except of course for the limit in the regional court. You still have to follow the limits. In the regional court, it will be 400,000 rand, and in the district court, it will still be 200,000 rand. Okay, before we move on now to parties, I'm going to quickly look and see which questions we have here. Okay, guys, which notes is he referring to? Or is he referring to the guide? Page 50. Please advise if what the lecturer is reading was shared with students. Okay, your study guide. Okay, we're on page 5. Thanks. So they recuse themselves. No, they don't recuse themselves. It's not an application for recusal, Saisha. It is rather an application for transfer of the matter to another court. I lost connection due to the power that went off. Chantalise, I hope you're back on. We're on page 60. Nomhle. All right, thank you. We are going to now move on, and we are going to be on page 62. We are going to start with parties now. Not the kind of parties where you dance and you are happy, but the persons in proceedings. Can we please mute our microphones and videos? Who is announcing their arrival here now? Ricky. Thank you. All right. When do we apply to recuse a magistrate? When a magistrate shows any signs of bias towards one party over another. When a magistrate acts unreasonably by allowing certain evidence and not by allowing other evidence in a court, that is when you may apply for a magistrate to be recused. I hope that answers your question. Now we are going to look at the different parties Rule 2, Subrule 1. In the definitions clause, refers to a plaintiff, a defendant, an applicant or a respondent, and even a party, to include the attorney or the advocate who appears for any such party, as well as an officer of any local authority nominated by it for the purpose. Now, an officer of any local authority could be an employee of a municipality. That is what a local authority is. Rule 5, Subrule 4 specifically states that every summons shall set forth the following information. So when you are drafting a summons to institute legal proceedings against someone on behalf of a client, you need to set out the surname and the first names or initials of the defendant by which the defendant is known to the plaintiff. Now, I do not agree with the initials, but only where you do not know the person's full names. I suggest that or recommend that when you institute proceedings against a defendant, try to obtain their full names, because you will find that using the person's initials only and surname, when the sheriff goes to serve those documents at the address which you have given, all 12 people living in that house have the same initials. And it happens in many families. People are even given the same names, so that you are not even sure as to which Vincent you are looking for. Is it Vincent Senior or Vincent Junior? So you better make sure that you rather cite the full names of the person if you have those names. Try by all means to get the full names. Secondly, you must set out in your summons the defendant's residential address, where they live, or their place of business where they operate, and where you know, if you know this, the defendant's occupation and their employment address. It's also important that you set out in your summons whether you are suing the defendant in their personal capacity or in their representative capacity. An example of representative capacity is a mother who sues as a plaintiff on behalf of her minor child for medical negligence against the MEC for Health. That's an example of representative capacity. She would, however, sue in her representative capacity as the mother and natural guardian of the child, and she could also sue in her personal capacity as having suffered general damages as a result of the negligence. Then you must also, in your summons, always set out the full names, the gender, and the occupation and residence or place of business of the plaintiff. You, the person who's suing the defendant now. And if you, the plaintiff, is suing in your representative or your personal capacity. It's very important that you know those, that you apply those principles whenever you draft a summons. So Rule 6, Sub-Rule 12, where you are suing as a cessionary now, the plaintiff, you must indicate the name, address, and description of the cedent at the date of session, as well as the date of session. If there is a written session, you must attach that session in support of the allegation to say, I am now the new cessionary, the new person, and the rights have been ceded to me in terms of a session agreement, and here is the session agreement. You must state so in your summons that you are a cessionary. Right, companies and close corporations. A company and a close corporation are considered to be juristic persons. In other words, they may sue or be sued in their own names. You don't have to sue the directors. You sue the company. The directors are separate entities from the company. Unless a director has bound him or herself as a surety and co-principal debtor of the company, you will always sue the company or the closed corporation. So the capacity for a company or a closed corporation to sue and be sued is called the locus standi in judicio or judicio. Directly translated as legal standing. In other words, do you have the capacity to be sued or sue out of a court of law? It may, as I said, it may be a juristic person, but it may also be a natural person. A natural person will be sued in their personal capacity or their representative capacity. Have a look at the case of four-wheel drive CC versus Leshny Rattan. Rattan NO, that NO stands for nomino officio, to indicate they are being sued in their representative capacity, either as a curator or as an executor. In that case, the court found that the plaintiff must have an adequate interest in the subject matter of the litigation, usually described as a direct interest in the relief sought. And this interest must not be too remote. It must be actual. It must not be abstract or academic. And it must be a current interest and not a hypothetical one. And there's a duty to allege and prove this by the party who is instituting the proceedings. So if your locus standi is representative or personal, you must disclose the facts or make the allegations in your particulars of claim to substantiate that fact. Now, all natural persons have the capacity to sue or be sued unless they suffer from some legal disability. Now, you may ask yourself, what is a legal disability? You know what a physical disability is? It's either you cannot walk properly or you cannot stand properly because your one leg is injured, permanently injured, and you are disabled. That's easy to understand. What is referred to as a legal disability? Now, all natural persons, by virtue of their birth, have the legal standing to sue and be sued, provided they are over the age of 18. That's the legal age. All human beings have the inherent right to sue and be sued as natural persons. There are exceptions to that. In other words, your legal rights may be defective and you may not sue or be sued because of that. And the first person that is disqualified because of that is a minor. And I'm not talking about a person who works in the mines, M-I-N-O-R. A person who is under the age of 18 years of age. You are said to be underage, you are not an adult yet, and you may not be sued or sue unassisted. I made the example earlier on of a mother who's suing the Department of Health on behalf of her minor child. Now, because that child's legal capacity or locus standi is deficient or defective, the mother has to assist that child in instituting legal proceedings. And if it was vice versa, if that child was to be sued by the department for any reason, the mother will have to be cited, or the child will have to be cited as being assisted by the mother. Now, the second group of persons disqualified from being sued and suing in law is persons with mental disabilities. Those persons are considered not to be able to comprehend legal proceedings. And that is where those persons will need to be assisted, either by a curator being appointed to them, or a guardian being appointed to them. So and you need to look at the test. There's a test for mental incapacity to determine whether a person has a mental disability. And this test was established as follows. The requirement is that the person concerned must have the mental capacity to understand and appreciate at a level which is sufficient to enable him to manage the particular affair in question. The question that arises, therefore, is what level of understanding of the legal proceedings is required before it can be said that the person concerned can manage his affairs in question, namely his litigation. Whose mic is on? Can you all please mute your microphones? Thank you. I believe that the answer to this question must be that in order to manage his own litigation, the person concerned must be able to understand the proceedings at a level which is sufficient to enable him to play a useful and constructive role during the proceedings by giving proper instructions to his legal representatives. Full stop, close quote. Now, if a person is not able to play a useful and constructive role by giving his legal representatives proper instructions, then that person is disqualified from having locus standi in judicio, in legal proceedings. Those are two examples, classical examples of where a person lacks full legal capacity to institute legal proceedings or to have legal proceedings instituted against. Another one is, and there's a topic here, married women. Previously, married women could not enter legal proceedings on their own. They needed the permission of their husband to even conclude a hire purchase agreement. They could not do so without their husbands, but the husband could do so alone without the wife. Of course, that was done away with because we have a constitution now and all of us are equal. But there is still a limitation on the capacity of married persons to sue. And that is that a person who is married in community of property may in certain respects not institute proceedings which pertain to the joint estate of the parties without the written consent of the spouse to do so. And an example would be if a property belonging to a married couple is to be sold by one of those parties or one of the couple, then that couple needs the written consent of their spouse in order to do so, because that property forms part of the joint estate of the parties. Now, other examples of juristic persons or entities are the various public higher education institutions like universities, colleges, and what do you call them these days? Technology universities, which are established in terms of the Higher Education Act. These are juristic persons and they have locus standi. They are therefore capable of suing and being sued in their own names. Bodies which are incorporated by statute, public schools, in terms of the South African Schools Act, are considered juristic persons. Another one is a museum. A museum is an entity in terms of legislation and can be sued and sue in its own name. Any two or more persons who claim or are being sued as co-partners may sue or be sued in the name of that partnership of which those persons were co-partners at the time of the accruing of the cause of action. In other words, if the right to sue existed at the time when the partnership was in existence, any two of the past or more of the persons who were partners can sue on behalf of the partnership or can even be sued on behalf of the partnership. Partnerships are a rare entity these days. And the Companies Act now provides for most entities, commercial entities, to be registered as companies, PTY LTDs, or just PTYs. So you would rarely find a partnership unless a partnership agreement is normally entered into between two or more parties as an informal way of starting a company. So it's very rare that you still find partnerships around. But where a partnership is formalized, it is a juristic person for all intents and purposes in terms of the law. And Rule 55 of the Magistrates Court's rules would apply in that respect. Now, a partnership also cannot sue or be sued in its own name. You have to cite the partners individually. And that's because it has no legal persona of its own, except under the National Credit Act, where it is said to be dealt with as if it is a juristic person. So once again, a partnership is not a juristic person. You must cite the partners. But for purposes of the National Credit Act, partnerships are considered to be juristic persons. Trusts. These are also quite funny. A trust is not regarded as having legal personality. There again, if you want to institute proceedings on behalf of a trust, you must cite yourself as the trustees. You can also be cited as if you are being sued. If the trust is being sued, you must sue the trustees of the trust individually. You must cite them individually, but you must put the words NO after their name, which I referred to earlier on, which is nomino officio, which shows that they are being sued or suing in their representative capacities. There's the case of Mariola versus K. Eddy on page 67 of your notes. NO 1995, volume 2, SA 728. It's a Western Cape Division case. Okay, I'm going to allow questions now. I'm going to break my own rules. I'm going to allow questions. ZD, guest, your hand is up. Is everyone experiencing the same, where the chat is being muted on and off simultaneously? I don't know because I'm not paying too much attention to it. Sir Kalen wants to know, sir, it's hard to follow without page number. It is easier when the information is front of you. Kalen, we are not reading notes here. I am lecturing you on the subject from a practical point of view. And I don't necessarily, I will refer to page numbers where I can, but you were supposed to also have read ahead and know what I'm talking about. To those of you who have joined us late, at the beginning of our session, I said that I will allow time later on for asking questions so as to not delay our progress. Last night, we wasted quite a bit of time because we had questions in between which hampered our progress. I see there's a hand up. Hassan?
Yeah, hello. Good evening.
Good evening.
Sorry, there's an echo coming, but it's not from. Just to clarify the matter around jurisdiction, so I want to sketch a scenario. Let's assume an accident happens in town A, right? So the cause of action, action is town A, but the plaintiff and defendants are from two different towns. Okay, let's say one is from town B, one is from town C.
Yes.
Can both consent to the jurisdiction of a magistrate's court in town D, Compound Sprate or wherever? Is that something that is possible?
Yes, it is possible.
Okay.
That is where the parties consent to jurisdiction of that court.
Right.
And the grounds would be because one of the parties resides there. The norm is that you follow the defendant to where the defendant either resides, carries on business, or is employed, or where the cause of action arose. Now, in this case, because the parties have agreed, they may agree to have the matter heard in another court.
Even if the place of residence or the place of business of any one of the parties is not that.
Yes, sir. Even if.
Okay.
Remember, we said earlier on that the parties may even agree to transfer a case to another court.
Okay.
Even if that court does not ordinarily have jurisdiction over the matter, the parties can agree to move the matter to another court for purposes of convenience. And I would guess that that would be the reason in this case.
Yeah, despite the cause of action having occurred anywhere else. So that doesn't
despite the cause of action having, yes, sir, despite the cause of action having occurred anywhere else.
Thank you very much, sir. Appreciate it. Thank you.
Pleasure, sir. Right, is there any other question? Will please repeat requisite of interim interdict? Well, surely we will deal with interim interdicts later on, please. Then I will deal with them. Okay. All right, let me rather do this then. Because there are no further questions, I will deal with the requisites for an interim interdict. In order to satisfy the court for an interim interdict, there are 4 requirements, which a party needs to allege and prove. The first requirement is that the applicant who is bringing the application has a prima facie right The second requirement is that there must be an apprehension by the applicant of irreparable harm occurring to the applicant if the interdict is not granted. The third requirement is that there is a balance of convenience in favor of the applicant being granted the application. And lastly, there is no alternative available. In other words, there is the absence of any other satisfactory remedy. In other words, the applicant has no alternative but to come to court. I hope I have answered your question, Mosholi. I will be generous and allow some more questions, relevant questions. I see we have 12 minutes before our break. Just looking at our program for today. As I said at the beginning of our session today, I will be skipping some topics in your notes. Please feel free to, if you feel I have not covered a topic which you think I need to, please let me know and I will come back and let you and deal with that specific topic. All right, Dolly wants me to repeat the final interdict pointers. Dolly, there are 3 pointers or requirements for a final interdict. The first one is that the applicant must show that he or she has a clear right to launch the proceedings. A clear right as opposed to a prima facie right. The second requirement for an interdict, or a final interdict, is an injury or harm which actually has been committed or which is reasonably apprehended of going to be admitted. In other words, it's imminent. And then lastly, the absence of any satisfactory remedy which is available to the applicant. And that can be found on page 50 and page 51 of your notes, Dolly. I hope I've explained that to you in a way that you can understand. Timakatso? Yes, good evening to you too. Yes, it is really necessary to take a break. I also need a break. Remember, I'm the one talking here, so I need that break. I get tired. We will still have time at the end. I will allow about 20 minutes for questions at the end, depending on how many questions there are. Do we have any more questions? Before we take our break at 7 o'clock, sorry. Okay. Since there are no questions, then I will start then with our forms of proceedings. There are basically three types of proceedings which can be instituted in the magistrate's court. And these are, number one, the action proceedings, also called the summons. Number two, the application proceedings, also called your motion proceedings. And number three, your provisional sentence proceedings. Now, it's important that you are able to distinguish between the first two, which is an action and an application. Because when a client comes to you for legal assistance, you must be able to tell your client, we are going to proceed by way of action or by way of application. And you must know how to determine which of those two options to follow. And the criteria that is used is that of dispute of fact. If you anticipate that there will be material dispute or disputes of fact between the parties, then the definite answer is for you to follow the action proceedings. Because then those disputes of fact can be addressed by way of oral evidence in court. Viva voce evidence. If, on the other hand, you do not anticipate that there will be material disputes of fact, then you may go by way of application. But these are not the only criteria to be used to determine whether to go action or applications. And I'll give you an example. The Divorce Act, for instance, provides that all divorces must be instituted by way of summons. So you cannot get divorced or you cannot institute divorce proceedings by way of application proceedings. You must go by way of action. Similarly so, you cannot or you may not apply for the sequestration of someone's estate by way of action. You can only do so by way of application. Now you will find that you can only bring sequestration proceedings by way of in the High Court, sorry, because it has to do with the status of someone. Right? So Rule 56 will then tell you that you have to bring an interdict or attachments to secure claims en mandament van spolie in terms of that rule, in terms of Rule 55. Now, Rule 55 is the rule that applies to all applications in the Magistrates Court. So it's important that you know where to find this at all times. Rule 55 will be your guide, and you'll see that it is a very long rule because it deals with applications at great length. And one more difference between an action and an application procedure is, in an action, you have a plaintiff and a defendant. That's how the parties are referred to. Whereas in an application, the parties are referred to as applicant and respondent. You will see as we progress, there are more differences between the two. As an action proceeding is commenced by way of summons. Either a simple summons sorry, I muted there. Either by way of simple summons in an action, a combined summons, or a provisional sentence summons. We will deal with these three different types of summonses at a later stage. And in your summons, you will set out sufficient facts to establish your cause of action, as well as your entitlement to the relief that you want against the defendant. And normally where you make use of a combined summons, it will be accompanied by a set of particulars of claim in which is set out those facts I've just referred to. In an application, proceedings are instituted by way of a notice of motion in which, like your summons, you set out the relief you are seeking against the respondent, together with a affidavit in which your particulars of your claim are set out in great detail. I also said that in action proceedings, summons proceedings, you lead oral evidence in a trial. So witnesses will testify and they will give viva voce evidence against in court in support of their claim. In an application, in application proceedings, the applicant and the respondent will set out their cases in affidavits. An affidavit is a statement of fact under oath. It is considered a sacred document. People have been prosecuted for lying in affidavits to show how sacred an affidavit is. And they have been charged with perjury for having so lied in affidavits. So when you set out your facts in your affidavit, make sure you give as much information as possible, because that and that only is your evidence in support of your case. But make sure that it is relevant information which you put into that affidavit to support your case. All right, I see that it's time for our break now. Timakatso? You don't have to take a break. I see you are not quite eager to have a break, but we are going to take a break now. See you at 7:15, guys. Right, we are back after our short break. I see that there is a hand up. May I please inquire Sari Sitole? Right, when we started this evening, I said that we should try to reserve our questions for the end of the session. We will be finishing a bit earlier, then we will have questions. Before our break now at 7 o'clock, I allowed time for questions, and the time for questions has now passed. We are now going to commence with our session, after which I will allow questions to be asked. So Sari Sitole, you may please put your hand down. Nyanesizwe Budaza asked a question. Which summon we use for liquid claim and which one used for illiquid claim? Now, Mr. Budaza, or Ms. Budaza, at the beginning of our session, I mentioned that last night, some of you asked questions regarding topics to still be dealt with later on in the session. This is one such question. Where does your question emanate from, sir, if I may ask? Mr. Budaza? Nyanesizwe?
About the salmon, so I was keen to know that.
From where, sir? Where did you read about liquid claim and illiquid claim?
I know that there is a liquid claim and illiquid claim. So from that context of salmon, I wanted to know which one fits where.
Did you read through the notes, sir?
Yes, I did.
When did you read through the notes?
Today, while I was at work.
Today while you were at work?
Yes.
And did you read about it there?
No, it was not there. So,
okay, then you did not read through the notes, sir, because it is there. Anyway, we will deal with it later on when I deal with the topic. It is on the list of topics to be dealt with this evening.
All right, all right.
And I will answer your question then, okay?
All right.
Thank you, sir. Ladies and gentlemen, I would like to please re-emphasize that we ask relevant questions at the relevant time. It impacts on our progress when we ask questions out of context. I'm not referring to this question, but at the beginning of our session, I said that some of the questions you are asking before we even deal with the topic. So please be patient and please give us a chance to deal with them, but I will try to deal with your topic before the end of with your questions before the end of the session. But please also, you are lawyers. You want to become lawyers. You must know which questions are relevant and when to ask relevant questions. It annoys other people who understand, but that does not mean you must not ask questions if you don't understand something, okay? Right, let's move along now. We said that there were three proceedings: the action proceedings, the application proceedings, and the provisional sentence proceedings. I've explained the action and the application. The provisional sentence proceedings are in terms of Rule 14, capital A of the rules. And provisional sentence is an extraordinary, summary, expedient, and an interlocutory remedy which enables a creditor who has a liquid document to obtain a speedy judgment without resorting to the expensive machinery of an illiquid action. So it's a quick remedy for a plaintiff who wants to sue a defendant where there is a liquid document. A liquid an invoice would be a liquid document. Another example would be a statement of account. A check is another example of a liquid document. In other words, you don't have to go to great lengths to prove your claim. It is there in the form of the check. So you can, when you issue a provisional sentence summons, attach the check thereto. When after the defendant has been served with that note, that summons, provisional sentence summons, you may immediately thereafter, when the time has lapsed for the defendant to enter an appearance to defend, and they have failed to do so, you may immediately apply for provisional sentence against that party without having to go the route of default judgment, notice of bar, and all of that. You can straight away apply for provisional sentence, and the judgment in your favor, the provisional sentence in your favor, will be the equivalent of a judgment, but you will have received it much more speedily than the others. Right, now we are going to start with the action proceedings as one of the three proceedings which I referred to earlier on. Okay, page 73, for those of you who would like to know. An action, also referred to the summons stage, can only be commenced by way of summons. And you will see in your notes at the end thereof, there are forms, different forms. Just want to find the correct page. And these forms start from page 240. There you will see a precedence of most of the pleadings and notices which you will be required to draft. If you look at the rules themselves have got the different pleadings, including a summons. Coming back to our page 73 now. So when you're drafting summons, you have to refer to rules 5, 6, and 7 for the guidelines with regards thereto. Remember, we mentioned that for you to when you're drafting summons, you have to set out specific facts, especially when you are describing the parties, the plaintiff and the defendant. And in an action, you may have one plaintiff, one defendant. You may have many plaintiffs, many defendants. Many plaintiffs, one defendant. One plaintiff, many defendants. So you have different scenarios depending on the facts of your case. That is how you will set out your information with regards to the parties and how you cite them. So after having drafted your summons, you will issue that summons out of the court, the relevant court. And the office you will go to, if it is in the district court, is the office of the clerk of the court. If it is in the regional court, you will go to the registrar of the regional court, who will issue you with a case number on your summons. They will also put a stamp, an official stamp, on your summons. On your summons must be included your claim, in which you will tell your client, in which you tell the defendant what you are suing them for, what they must do if they want to defend the action, when they must defend the action, within how much time must they defend the action, and how they must defend the action, what they must do to defend the action. They must file a notice of intention to defend within a specified period of days. They must file a plea within a specified period of days. Or they may file a counterclaim together with their plea, all within a specified period of time. And the period is normally 20 days within which you must do so. Organs of state have a longer period. It's normally 30 days in respect of organs of state that you have to give them to file a notice of intention to defend, as well as file a plea. Where a claim is for a debt or a liquidated demand, you may use a simple summons. Yana says, I hope you are listening. Where the claim is for a debt or a liquidated demand, the summons may be a simple summons. In other words, where it is a determined amount which can be proven by the document, like a check, you can use a simple summons. Where it is a liquidated demand, in other words, you know it is easy to ascertain the amount due. If it is for a debt, also, you may use a simple summons. Where the debt is illiquid, in other words, it is not easily ascertainable in rands, you should use a combined summons with particulars of claim, in which you set out in detail how your claim is made up. And an example of an illiquid claim, as you have stated it, is a claim for damages arising from medical negligence. You do not know what exactly the claim is that your client is entitled to, because it is an amount that has to be calculated, that has to be proven at the end of the case. It cannot be proven at the beginning or in the middle of the case. It can only be proven at the end of the case when the reports which support that claim have been filed. I hope I've explained it. We spoke about a debt or a liquidated demand in terms of which you may use a simple summons. And here are examples on page 73 of such debts or liquidated demands. And an account and a debatement of it, arrear rentals, cancellation of a lease agreement, eviction in terms of a cancelled lease agreement, that's a liquidated demand. Cancellation of a contract of sale, that's also a liquidated demand. Eviction based on cancellation of sale or conclusion of a new agreement, also liquidated demand. Cancellation of an agreement and forfeiture of installments paid in terms of it. An interdict preventing trespassing. Failure to pay due maintenance. Delivery of property and work done and material supplied. Those are examples of a debt or liquid document, liquid demand. Now, the following are examples of claims which have been held not to be a debt or liquidated demand. The first one is collection costs. Second one is payment of monies held to be due after the debatement of an account. Monies due by a deceased estate, where the executor had excluded it in the liquidation and distribution account. And lastly, payment of a penalty. Those are considered not to be a debt or a liquidated demand. In every case where the claim is for a debt or liquidated demand, we said the summons shall be, remember we said may be previously, here it says shall be a combined summons, where it is not for a debt or liquidated demand. Now, every summons shall be signed. It is a rule. It is a requirement that every summons be signed by a legal practitioner acting for the plaintiff. And that summons must have or show the legal practitioner's physical address, which should be located within 15-kilometer radius of the court. If it is not, if your office is not within 15-kilometer radius of the court, then you must use the services or appoint a correspondent attorney with offices within the 15-kilometer radius of the court. Also on your summons must be the legal practitioner's postal address, and where available, the legal practitioner's facsimile address and electronic email address. Now, email address or electronic mail address is something which has been introduced into our legal system fairly recently. And with the onset of COVID-19 2 years ago, it has become more prominent in use amongst legal practitioners. Those of you in Gauteng will be familiar with Case Lines, which is an electronic system on which you can load your proceedings. You can submit them to the registrar's office, The registrar will issue your papers on case lines, and then you will get your documents back electronically. Everything is done electronically. In some parts of our country, some divisions still do not use case lines or any electronic media means of filing. And where that is the case, the practitioners themselves must agree that service of pleadings and notices can take place by way of electronic mail. In other words, email. But it's only where the parties' legal representatives agree between themselves. You will get some legal representatives who will refuse. They will refuse to be served via email. And that is unreasonably so, because it just speeds up the process. It does make things much easier and more speedy if the parties exchange pleadings by email. If a party is not represented by a firm of attorneys, the plaintiff, him or herself, must sign the summons. And the plaintiff, him or herself, must in that summons indicate their address, their physical address, which must also be within 15 kilometers of the court building. And the plaintiff must also indicate in that summons a postal address, and if possible, a fax and an email address. The registrar or the clerk of court, when a party comes to issue a summons, must sign the summons. Either the registrar or the clerk of court, depending on which court it is. And the date of that summons being issued must show on the registrar's stamp, which is put on the summons, as well as the case number which has been allocated to it. And there again, if the plaintiff is representing him or herself, the plaintiff may indicate in the summons if they wish to receive documents by way of email. If that summons or the action becomes defended, then the defendant may, only at the request of the plaintiff, consent in writing that service of documents by both parties may take place via email or facsimile. I don't think anyone is using facsimile anymore. It's one of those outdated things that have come along with the advancement of time. And if a party unreasonably refuses to consent in writing to the parties serving by email, the plaintiff may apply to court for the court to order the defendant to agree to file documents via email. So even the courts are now on the bandwagon because they also want cases to move along more expeditiously, to have parties exchange pleadings electronically. It just makes everyone's life more easy. I've already stated previously that in your summons, there is specific information that must be there. The surname and first names or initials of the defendant, by which the defendant is known. But by all means, try to get the full names. If not, initials will do. But there's always a trap to that. And I've explained earlier on that there may be persons in the same household with the same initials or the same names even. So try by all means to get the full names. Also, what must appear in the summons is the defendant's residence or place of business, and if known, the defendant's occupation and employment address, and if the defendant is sued in their representative capacity or personal capacity. The full names of the plaintiff, the gender, and if the plaintiff sues in a representative capacity, such capacity. And every summons shall include a form of consent to judgment, a form of appearance to defend. So the defendant must have the option on the summons. So you as plaintiff must make sure that the summons contains these options. And the first one is a consent to judgment. In other words, without the party having to go to court and all of that, the defendant can, on the judgment, on the summons, consent to judgment. On the same summons, the defendant must be able to appear to defend the case. The defendant may also be drawing, a notice. The summons shall also include a notice drawing the defendant's attention to the provisions of Section 109 of the Act. Now, what is Section 109 of the Act? We need to, like good lawyers, go there and find out what Section 109 is all about. Section 109 is where a judgment debtor has to inform the court of his or her address. So where a litigant has obtained judgment against a party, that party is obliged in the notice. The plaintiff can, in the summons, draw the attention of the defendant to the provisions of Section 109 that oblige the defendant to disclose his address for purposes of execution of the judgment. And then also, in the summons must be included a notice in which the defendant's attention is directed to the provisions of sections 57, 58, 65A, 65D of the Act, in where the action is based on a debt referred to in section 55 of the Act. Now, all of these sections I've just read to you now, 57, 58, 65, and 65, relate to debt collection proceedings in the magistrate's court. So if your cause of action is based on section 55 or any of these sections just referred to now, you must include in your summons a notice drawing the defendant's attention to those sections and the provisions thereof. A summons shall also contain an allegation that the whole cause of action arose within the district or the region and set out. Now, it is not, I've seen in many summons that, or particulars of claim, plaintiff will set out will make the allegation that the whole cause of action arose wholly within the jurisdiction of the above honorable court. Full stop. That's all they will say. They do not elaborate as to how the whole cause of action arose within the within the region, the district or the region of the court. Another one, which I find many times in summons and particulars of claim, is where the plaintiff says, the above honorable court has the jurisdiction to entertain this matter. And they full stop there. They do not go on to explain how the court has jurisdiction. What facts are relied upon to say so? And the defendant is left to guess at the end somewhere or in between how the court has jurisdiction. So when you draft that clause on jurisdiction, state specifically why the court has jurisdiction. If it's because the defendant resides within the court's jurisdiction, then say so. If it's because the defendant carries on business in the jurisdiction, then say so. If it's because the defendant works or is employed in the district or in the court's jurisdiction, then say so specifically. If the plaintiff abandons any part of the claim, that must be shown in the particulars of claim or summons. If you are relying on a contract or legislation in terms of which the plaintiff has performed or complied with any requirements, you must state so in your particulars of claim. Give full particulars thereof. If it is summons in respect of the National Credit Act, make the necessary allegations with regard to Section 129 and Section 130 of the National Credit Act, and say how you've complied with those provisions. Attach the necessary letters, copies of the letters, as well as the proof of the registered service and the track and trace report, which shows that the letter was actually collected at the post office. If a summons is in respect of rent, Section 31 says to you there's a specific form that must be used, so make use of that form. If a summons is in respect of a declaration of a property executable, immovable property executable, in other words, a house or a property, which is the home or residence of the defendant, there must be a notice attached to that summons to the following effect: drawing the defendant's attention to Section 26(1) of the Constitution, which accords to everyone the right to have access to adequate housing. And in your summons too, you must make the allegation that there are no elderly people in the house. There are no single parents in the house. There are no minor children in the house. Those are some of the allegations you will have to make when you are issuing summons to declare property, immovable property executable. And obviously this will relate to properties under the value of the jurisdiction of the relevant court. Right, now, here are some rules relating to pleadings generally. We've already said that every pleading must be signed by a legal practitioner, and the party himself if there's no legal practitioner representing them. Every pleading must have a title, right? The title of the action describing the parties thereto and the case number at the head of each pleading. So at the top, you will have in the Magistrates Court for the District of Mpumalanga. No, not Mpumalanga, sorry. Polokwane. In the Magistrates Court for the District of Mpumalanga, held at Mpumalanga. On the right-hand side of your document, you have the case number. You have a space that says case number. You do not allocate your own case number. The clerk of the court will issue it because we are now in the district court. In the matter between Joe Soap, plaintiff, and Jane Doe, defendant. Then your heading will be summons, be it a simple summons or combined summons, or a provisional sentence summons. And you must use the correct pleading of citation of the headings, as well as the parties on every document. The information I've just referred you to now must appear on every pleading of relating to that case that you are dealing with. That action, particularly that action. And where it is in the regional court, you will say in the regional court for the regional division of Polokwane, held at Polokwane. Abbreviations may be used if the title is lengthy. Every pleading must be divided into paragraphs, and those paragraphs must be numbered chronologically, starting from 1, of course. And each paragraph must contain a distinct allegation with regards to the cause of action. Your statements must be clear and concise and include the material facts which you rely upon. If it is your particulars of claim, your facts must be clear in respect of your cause of action. If it is a plea, the facts must be clear with regards to the defense you are raising in objection to the plaintiff's claim. Now, your answer that you give to any pleading must be sufficiently particular to enable your opponent to be able to reply thereto. There are 4 things only which you can do as a defendant to a claim. You must either, to any allegation, either admit, deny, or confess and admit. Those are the 4 pleas that are permitted in civil proceedings. This is not including special pleas. A special plea is raised differently. And a special plea is a legal point which you are raising in respect of anything contained in the plea or the particulars of claim. You can raise a special plea to particulars of claim as well as to a plea. I beg your pardon, a counterclaim, not a plea. And when you are denying an allegation in summons or particulars of claim, you cannot merely deny and leave it right there. You must explain why you are denying the allegation and preferably put forward a version to refute the version of the plaintiff. And even when you are admitting any allegations in particulars of claim or summons, you may go on to elaborate as to why you are admitting those allegations. Now, when you are pleading in respect of a divorce, in a marriage out of community of property, you must claim division, transfer, or forfeiture of assets. That is incorrect. You don't claim division out of community of property. You only claim division out of community of property where there is an accrual, where there is the accrual which is applied, and where it is out of where and where the marriage is in community of property. Then you also set out the details of the grounds of such claims which you must give in your particulars of claim. When you are suing for damages or you're drafting summons for damages, the defendant who is going to read your claim, your particulars of claim, has to be able to assess the quantum of your claim. In other words, the rands and cents must show as to how much they are being sued for. In terms of damages for personal injury may be a claim against Road Accident Fund, or a claim against the MEC for Health, or against a natural person for personal injury to you. In that case, the plaintiff must make the following allegations. Must, not may, must. Plaintiff's date of birth is important because they need to establish the age of the person, the nature and the extent of injuries. It's important to know how were you injured and how serious those injuries are. And the extent refers to whether they are temporary or permanent injuries. The effects and the duration of the disability, if any, which is alleged to give rise to such damage. There again, it's either temporary or permanent. And you should also state separately what amount, if any, is claimed for different heads of damages. For example, the medical and hospital costs and how you arrive at the amount of those costs. The medical costs and hospital costs and how these costs are arrived. Can you please mute your mic? Can you please mute your microphone? Also, when you are claiming damages for personal injury, you must allege, you must state the amount for pain and suffering that you are claiming, whether that pain and suffering is temporary or permanent, and which injuries caused that pain and suffering. You must also set out the disability in respect of the earning of income, earnings lost to date, and future loss of earnings. You must also set out in your summons or particulars of claim the disability in respect of the enjoyment of amenities of life, what those amenities of life are and how you've lost that enjoyment. Disfigurement, a description thereof, and state whether it is temporary or permanent. Those allegations will all assist the court in coming to a determination of what the quantum is that may be payable to the plaintiff in the end. Because the parties don't always agree. And that is why they are going to court in the first place, is because they do not agree. Damages resulting from death of another, the date of birth of the deceased and that of the person claiming damages as a result of death. Now, the reasons for that is they need to establish how old the person was when they died. You need to also establish the age of the person who is claiming, to establish the financial dependence, if any, and to make the connection between the two. There are, of course, many other allegations which you need to put in there, but These are the most important ones. If you rely on an agreement which is governed by legislation, you must state the nature and the extent of your compliance with provisions, as we said earlier on. The same would go for contract. And for cessionary, the names and descriptions, address of the cedant, as well as the date of the cession, as well as, and I said earlier on, if there's a copy of the cession, if it's in writing, provide a copy of that cession. If you fail to comply with these provisions we've just dealt with now, the pleading shall be deemed an irregular step and opposite party shall be entitled to act in accordance with Rule 60, Sub-Rule A. Now, in terms of Rule 60, Sub-Rule A, you give the other party a notice to say to them, your pleading does not comply with the provisions in that you have not made the relevant allegation, or you have not signed the document, or you have not, or you have referred to the incorrect court, you have put down the incorrect case number. That makes it an irregular step, and you can complain. If the party does not remove that complaint within 10 days of you giving them written notice, you may bring an application to have that step declared an irregular step and even struck out. It could have a grave impact on the plaintiff's claim if it's a claim, because you could then strike out the plaintiff's claim, which means that the case is dead. And if it's the defendant, the plaintiff can strike out the defendant's defense, which leaves the case undefended, right? Before you issue summons with the registrar or the clerk of court, you may amend the summons time, provided you have not issued it yet. But after you've issued the summons with the registrar or the clerk of the court and you wish to amend anything in there, for instance, the spelling of a name, for instance, the address, the amount claimed, or any mistakes which are made in there which you've noticed after having issued the document, you must give your opponent notice of your intention to amend the document. And then they have 10 days within which to object in writing to any amendment should they feel so. Make sure that you know the facts thoroughly, and that's when I said last night that you should, when you consult with your client, you listen very carefully, you take down meticulous notes so that you can get the facts in support of your cause of action correct and accurately. Then, when you draft, you also have to do your research before to make sure that your facts support a cause of action that is permissible in law. If it's on delict, if it's based on delict, make sure you know what the elements of that delict are that you have to meet. If it's on contract, make sure you make the necessary allegations to support a claim for in respect of contract or breach of contract. So you must always make sure that your summons or particulars of claim set out or disclose a cause of action. If you do not have a cause of action, you have no case. And to satisfy yourself as to what a cause of action is, look at the cases on page 81 of Mackenzie versus Farmers Cooperative Meat Industries Limited. And you will see that this is a 1922 appellate division case. 1922, exactly 100 years ago. And it still stands. Because in that case, it was set out that every fact which it would be necessary for the plaintiff to prove, if traversed, in order to support his right to judgment of the court, it does not compromise every piece of evidence which is necessary to prove each fact but every fact which is necessary to be proved. That was what was referred to as a cause of action. In Abrams versus and Sons versus SA Railways and Harbors, which was a case decided 11 years after Mackenzie, in 1933, in the Cape Provincial Division, it was said that the proper legal meaning of the phrase cause of action is the entire set of facts which give rise to an enforceable claim and includes every fact which is material to be proved to entitle a plaintiff to succeed in his claim. It includes all that a plaintiff must set out in his declaration in order to disclose a cause of action. In an action, it is different to an application as to how you have to prove your case. Because in an action, in addition to your summons and particulars of claim, you have the opportunity by way of viva voce evidence. Viva voce evidence or oral evidence in court by your witnesses to support your and prove your claim. So you do not have to plead evidence in your claim. You do not. You must be careful not to plead evidence in your claim. I've seen many practitioners when they draft summons and particulars of claim, they plead all their evidence in their particulars of claim. And how do you challenge evidence in a pleading? You cannot. You challenge evidence in the court under examination in chief, cross-examination, and re-examination. Some parties will even take chances and request further particulars which amount to evidence which is to be led in court. And other practitioners fall for the trap by providing that evidence to them upon request. So you must know when to discern that it is a fishing expedition or it is a genuine request for further particulars. Now, it's explained here in legal terms as well that you have to draw a distinction between the facta probanda and the facta probantia. The facta probanda is the facts which must be proved in order to disclose a cause of action. And a facta probantia is the facts which prove the cause of action. What the facta probanda are in each particular case is essentially a matter of substantive law and not of procedure. Substance, not form. Here are some cause of actions, examples of causes of action. A party wishing to claim specific performance in terms of a contract must prove the following: the existence of the contract, firstly, and then secondly, allege and prove the material terms of that contract, and then allege and prove that he has complied with these obligations in terms of the contract, and then allege non-performance by the defendant of his obligations in the same contract. And then next, you must allege the nature of the relief that you are seeking, and you must then also address the issue of costs. What follows then are other examples of the allegations you must make the cause in order to establish the cause of action in the different types of causes of action. There's delictual claims. There is one for a claim on a dishonored check against a drawer. There is a cause of action in a claim against a surety. There is also a claim for commission by an estate agent. There's a claim for the repayment of a loan, taking into consideration whether such loan falls within the ambit of the National Credit Act or not. There's also a claim for interest. Okay, interest is not a very tricky thing, but you have to at all times be familiar with the interest rate that is applicable. I think at this point it is every month when they announce on television that the repo rate is this much, the legal rate is also calculated at the same rate, by the way. I think at the moment it is 10.5, 10.75. I may be wrong. Let's see. Not that. Just want to quickly. Right, the legal interest rate, South Africa. The legal interest rate excuse me. No, I don't seem to find it right now, but I will look it up and I will get back to you. I will get back to you, but the interest rate fluctuates all the time. It does not stay the same, it fluctuates. So you have to know what the legal interest rate is at the time, so that in your particulars of claim, when you set it out, you must state what the interest rate is that should be applied. In terms of contracts, acknowledgements of debt, mortgage bonds, deeds of sale, normally the parties agree to an interest rate in there, as well as the issue of costs, which are normally on an attorney and client scale. So you have to be sure as to the interest rate that is applicable at the time. Familiarize yourself also with the Prescribed Rate of Interest Act 55 of 1975, which relates to specific terms and claims. I see we are almost at time. Quickly, before we take questions. Rule 9 provides that summons is to be served only by the sheriff. Now, the sheriff was also referred to as the messenger of court previously. And the sheriff was the person who had to serve summons on defendants after they've been issued, of course. Rule 9 provides the different ways in which the sheriff may serve summons on a defendant. May serve it personally on the person, may serve it at the residence or place of or business of the person. But if it's at the residence on a person other than the defendant, that person must be not less than 16 years of age and apparently residing at the place or employed with the place, if it's the employment of the person, then it must be explained. The process must be explained to the person that, and they must be able to understand what it is that they are receiving. The same happens, the same applies to the person's place of employment. In contracts, normally there is a provision that service may be effected, especially in terms of properties, mortgage bonds, that service may be effected at the domicilium address. Domicilium citandi et executandi is what it's referred to. That's called the domicilium address, which may even be a vacant plot if the address is in respect of the property, which is the subject matter of the contract or the mortgage bond. It may even be that vacant plot. All the plaintiff has to do is to prove that that was the address that was agreed to, and that was the address where the sheriff had served. Even if the sheriff has served, has put that piece of paper under a rock on that vacant earth, it is considered proper service in the right circumstances. It is only when the defendant decides to defend the action and for whatever reason want to use the fact that they did not receive the summons because it was left under a rock or because it was left under in front of a door and the wind blew it away, then only does it become a contentious issue. But normally, if the parties have agreed to that manner of service and at that address, then so shall it be. Right. Time for questions. We have time for questions now.
Advocate?
Yes.
Yes. I think on the issue of jurisdiction with regard to the amount of 400,000 for the magistrate court.
Yes, sir.
Yes, and if then as the parties, maybe I've got a bigger claim, and now as the parties we may say, okay, let's consent to the jurisdiction in terms of section 45. So that will mean in an amount of 600, it may mean basically my claim will be purely limited to 400,000.
If you consent.
If we consent.
No, sir, it does not mean that. It means if your claim exceeds the jurisdiction of 400,000 and it's 600,000, if you can get the defendant to consent in writing in terms of section 45 to the jurisdiction of the regional court, then the court may entertain the claim for 600,000 rands, but provided that the other requirements for jurisdiction have been satisfied. The cause of action arose within the court's jurisdiction, the defendant resides within the court's jurisdiction, then the court will accept the written consent by the defendant to institute a claim for 600,000 rands.
Thank you, Advocate.
My pleasure, sir. Hassan, I think your hand was up.
Yeah, thank you. So my question is related to the proper drafting of particulars of claim. So it says over here, it must be divided in paragraphs which shall be numbered.
Yes, sir.
And my question is, does that necessarily mean one sentence per paragraph? And
no, sir.
Within the paragraph, I can understand the semicolons appearing, but can they be full stops and more than one sentence describing the same point?
All right, that's a good question. Now, a paragraph is not restricted to a sentence only. A paragraph shall contain relevant facts relating to a specific point in particulars of claim. It may consist of more than one sentence, but the idea is to keep one paragraph restricted to one point. And I will make an example for you. Paragraph 1 of your particulars of claim. The plaintiff is Joe Soap, full stop. The plaintiff resides at number 12, 7th Avenue, Parklands, Johannesburg, full stop. The plaintiff is an adult male employed as a male nurse, full stop. The plaintiff is cited and is suing in these proceedings in his personal capacity, full stop. Do you get the idea? That is still one paragraph.
Yeah, thanks for that clarification. Yeah.
Thank you, sir.
I appreciate it. Thank you.
My pleasure. Any other questions?
Can I ask one more quickly?
Yes.
Yeah, I know that
I'm
others need the opportunity too, but very quickly. So we as inverted comma lawyers, but unadmitted, are we actually allowed to go to court and have summons issued? You did indicate it has to be signed by a legal practitioner, but one can do it if one is unrepresented. So
if you are the party, if you are the plaintiff, you may issue it yourself. Yes.
Okay, thank you. That's it.
And you may sign it yourself.
Thank you.
Antoine?
Yes, sir. I just want to refer back to page 35, where we discussed the execution against the state. I don't know if I misunderstood you there, but as I read it on page 35, we can't attach any property of the state. In accordance with the amendment, no execution, attachment, or like process shall be issued for the satisfaction of a final order of court, signing in money against the state for the property or the property of the state. The amount which is required to satisfy any final court order must be paid out of the National Revenue Fund or the Provincial Revenue Fund. Am I correct in that?
Yes, you are correct.
Okay, thank you, sir.
That says that any money owed by an organ of state will be paid out by the National Revenue Fund or a Provincial Revenue Fund. It merely says that it's not that organ of state that will be paying out the money. The money will be coming from the National Treasury or the Provincial Treasury.
Okay, so in what instances then would they attach, and the municipality itself or the organ itself have to set out the items that should be attached or should not be attached?
In which circumstances?
Yes.
Okay, it will be it merely says that the sheriff cannot just go and attach any asset belonging to that department. It merely says the sheriff must let the accounting officer point out which property can be attached. Am I clear?
Oh, okay. Yes, thank you, sir.
All right.
And then just one more question, sir. My apology, My apologies if this is outside of the scope, and feel free to decline to answer it. But I just want to ask, with a provisional sentence summons, right?
Yes.
What submissions would one make at court in front of the magistrate or herself when dealing with such a provisional sentence summons?
As a
Because I know
plaintiff.
that, yes, as the plaintiff.
Well, you would in a similar fashion as you would in a default judgment application. You make the following allegations to the magistrate. This is a claim for provisional sentence summons, for provisional sentence. The claim is based on a liquid document, which is attached here to, and it is marked that, and it's for this amount. The summons was served on the defendant on this date, and in terms of which the defendant was to have entered appearance to defend by this date. Period has lapsed, the defendant has not entered appearance to defend, and therefore is not defending the action. You therefore pray for provisional sentence against the defendant. And you tell the court that you have satisfied the requirements for provisional sentence, and if the court is so satisfied, it must grant you that relief.
Okay, thank you very much, sir.
Pleasure, sir. Right, I see there is quite a bit of, there are some questions here. Cleopatra, in a case where the plaintiff is representing themselves but are outside the 15-kilometer radius of the court, how does that work with regards to appointing correspondence attorneys, as is the norm with legal practitioners? Just curious. All right, Lady Cleo. What happens in that case is that the plaintiff must find a person with an address, not necessarily an attorney or a legal representative, a person who resides within the 15-kilometer radius to use as an address at which they will receive papers relating to that case. I hope I've answered your question. I'll move on to Saisha Rose. I won't attempt to pronounce your surname. I apologize asking something out of scope, but when we do issue a Section 65 financial inquiry, if it before or after it, I'm confused because I thought if the defendant does not pay or make an arrangement, don't we attach their movables? Then when do we do the financial inquiry? You do the financial inquiry when you have obtained judgment against the debtor. I'm using my rusted experience in Section 65 proceedings. But you use my memory seems to tell me that you only do a financial inquiry after you've obtained judgment against the execution debtor. Then you call them in because you want them now to make an offer of how they are going to settle the debt. Have I answered you, Saisha? And are you satisfied with the answer? All right, I see we are on 29 minutes to 9. Does anyone still have any final question before we? Okay, Saisha has gone further. So after obtaining judgment, then only you send the notice for financial inquiry. So after obtaining judgment, then you only can send the notice for financial. After obtaining judgment, then only you send the notice for financial inquiry. Yes. And when the person is unable to, and normally a financial inquiry can also be done after you've issued a writ, because then you've sent the sheriff and the sheriff has not found any assets that are worth attaching. Then you can also embark on a Section 65 inquiry. Because you cannot, realize any attachable property to satisfy the debt, you now issue a writ. After you've issued a writ, then you then you send out the Section 65 financial inquiry notice. It's an absolute pleasure. Thank you, team. It was wonderful spending time with you this evening again. Please read ahead as you have done for today. And tomorrow we will have another session at which we can deliberate on these issues. Jacob Leroke.
Hello, Advocate, and thanks so much here for giving me this chance to say a word or two. I sadly missed today's lecture because of the load shedding. So I wanted to know about the preparation for tomorrow. Which ones are they, if I don't waste your time?
Okay.
Thank you.
Okay, good. I was just about to come to that now.
Yeah, okay, all right, fine. Thank you. Thank you.
Tomorrow, the 17th of August,
yes,
you must prepare particulars of claim.
yes,
You can also start on defended actions.
mhm. That's it.
Defended actions and further particulars.
That's right.
So it's particulars of claim,
Yes,
defended actions,
that's right.
and further particulars.
And further particulars. Thank you very much, sir. Okay, thank you very much.
And also, if you have any other questions from previous sessions that
Right.
you would like to ask, make notes of them. Like I've done today, and I see that it's worked well. I will allow for time just before we finish for you to ask questions, and then hopefully I can answer those questions. But thank you everyone for your participation this evening. Enjoy the rest of your evening, and we shall meet again tomorrow, same time, same place.
Thank you, Advocate.
Thanks, Advocate. Good night.